Welcome to eDiscovery Leaders Live, where I get a chance to chat with luminaries in eDiscovery and related areas. This broadcast is sponsored by Reveal-Brainspace, the industry's leading AI eDiscovery platform. Don't forget to subscribe to watch me, George Socha, weekly with leaders in eDiscovery. Thank you for tuning in. Welcome to eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. I am George Socha. I head up brand awareness at Reveal. On each episode of eDiscovery Leaders Live, I get the chance to chat with luminaries in eDiscovery and related areas. Past episodes are available on the Reveal website. Go to revealdata.com, select resources, then select eDiscovery Leaders Live. Our guest for this episode is Philip Weldon. Phil is Director of eDiscovery and Litigation Support Technology at Kaplan, Heckler, and Fink. Phil, welcome.
Hello. Thank you so much for having me. I'm so excited to be here. And it feels like a real honor and privilege because while I don't necessarily consider myself a leader in eDiscovery, I do certainly consider you, George, one of the top people and top minds in the field. And so I feel honored to just be here in person.
Well, we are glad to have you here. I'd like to start before we get into the substance of our discussion today with you telling us a little bit about how it is you ended up in eDiscovery and in your current role.
Sure. So in eDiscovery, so I've been in eDiscovery for, I want to say, 23 years. Describing one's origin story is always kind of an interesting thing because you kind of take the frame of reference of that person based on their origin, even though I feel like all that I've done since is a better descriptor, but I'll still give you my origin story. So in college, I started, before I graduated, as a paralegal for a small medical malpractice law firm. And I had the whole intent of going to law school and becoming a lawyer. And after I graduated, they loved working with me and they gave me a full-time position. And so I thought it was going to be a very short stint before I went to law school. But getting into the thick of writing, I soon discovered that I really hated that aspect of what I was doing. So that was definitely not for me. But what I loved, the thing that surprised me the most, was at that law firm, we were going to trial like every other month. And I just had such a blast in the courtroom, sitting hot seat at that time. And this was a long time ago. I was doing everything with PowerPoint. So before me, they were doing, obviously the huge boards and whatnot. And so I was doing everything with PowerPoint. I was trying to mimic trial director. And then I got into trial director, and then, my love of technology just kind of progressed from there. So I've always been what I would consider an early adopter. And so I will try out the new thing whenever I see it, just because I enjoy tinkering and playing with things. And so that over the years, I think has served me well because I tend to play with the new tech personally first. And then I can introduce, attorneys to how it may help their workflows. As one example, I've been using ChatGPT for a while now, and one of the things that I'm doing next week is I'm going on vacation, and I have ChatGPT to thank for planning the entire trip. And so I'm going to, see how that works out. I'm going to a country where I don't speak the language, to a city that I've never been, with an agenda that I haven't totally reviewed. And so it will be an exciting adventure to see how that plays out next week.
Well, I hope you have a great time with that. Now, you are at the law firm of Kaplan, Heckler, and Fink, and it is that law firm. You've been involved with a relatively prominent trial of late that you said you'd at least chat with us about. So
Sure. So
what can you tell us?
we've had a lot of press lately for the E. Jean Carroll case, and while I won't obviously disclose any details about the case or any of the stuff that's going on, it has been all over the papers. It's been in the New York Times, the Washington Post. We've had a lot of positive press. What I will say from my own personal experiences working with the firm is that I've been in almost exclusively big law for most of my career, and I can tell you that where I am now, I am working with some of the smartest and most passionate attorneys that I've ever had the pleasure to work with. And the other thing that I always tell everyone is that they are also super kind, and flexible and easy to work with. And so it's like this. Normally in litigation, you're dealing with, super stressed out people that are angry or dealing with, terrible things. And here it's like, we're at this unique place where we have some of the smartest people dealing with some of the most high profile, intense cases. And they are just operating as though they are players in like the World Series. It's incredible. And I feel so blessed that I was selected for this role and I'm able to fill that. I certainly don't think that I'm up to the scale that the attorneys that we have here, but it's incredible. And so highly encourage folks to read about the case, the E. Jean Carroll case in the papers. It's incredible.
At least two questions. First, how do you think those attorneys manage to maintain their equanimity in such a high pressure situation?
I think it's two things. Number one, I think it's a passion for the cases that we work on. And so we do a ton of pro bono, and a lot of our cases, it's very easy for folks of like minds to be passionate about those cases. And then the other thing that I'm constantly surprised by is everyone works out. And it's like, I myself, I run 7 miles a day. I'm doing races regularly. And like, when I bring that up to other people, I'm constantly surprised that they are also doing lots of workouts and like other things. And so I think one component to it is just that people have found, exercise can be a helpful way to reduce stress in high pressure environments. And so I think that's part of it. I've been really surprised. I don't think I've worked at a place with as many fit people as there are here. And I think that's just a testament to everyone being on their A game, trying to be at optimal performance for the work.
Yeah, that does not sound typical of what I've seen at law firms over the years and the decades. Second question then, to the extent there's anything you can share, are there any eDiscovery related insights that come from this most recent lawsuit?
Actually, not from this most recent one. What I will tell that I was surprised about coming here is that the attorneys here are very technical and they're very fluent and they are good with text message reviews and other data types that you wouldn't normally expect attorneys in a law firm to be like fluent with. And I think the reason for that is we do so much pro bono work, and in a lot of those cases, we get data dumps from the government that just include a ton of Celebrate images or other forensic containers. And the attorneys here are already so passionate about those cases that they have just dived in, and before my role even existed, they were figuring it out. Obviously with a lot of help from the fantastic IT team. I tell everyone that the IT department is run by a savant. He's just gifted with computers in a way that I've never seen someone else before. So I think that's probably a big component of it. But also, the pro bono causes just encourage folks, I think, to dive more into the data types than you would normally expect. Back in the day, years ago, I've been on cases at other law firms where, the partners didn't even want to get into the mobile component, just because the data type was so tricky and difficult to deal with. Whereas now every case has a mobile component. It's hard to have a case that doesn't have that.
Earlier this year, in March of this year, there was a report issued called the Goldman Report. So give us your take on it and give us your spin on it.
Yeah, so there's been a lot of press around this report, specifically some of the dramatic conclusions that they came to in that report. And one of the big headline that everyone talks about, that they were talking a lot about at Clock, was 44% of legal work could be automated. Was one of the dramatic conclusions in that report. And I think there's a lot of people that are surprised by that. I would actually go further and say that percentage is quite a bit higher. But I will treat that a couple of different ways. Number one, I think the volume of legal work could be more automated, higher than 44%. I think it's probably close to 60 or 70%. But I think what can be automated is actually a ton of really dumb work that nobody wants to do anyways. And so George, as you're familiar with active learning, technology-assisted review, there is a ton of data that we can cut through with the advanced technology that we have. And so that aspect of the legal work can totally be, set aside, or you can amplify your coding decisions with, active learning, if you're doing it in a statistically valid, defensible approach. But I think that aspect of the legal work can definitely be automated. And I think, I don't think that means there's going to be less attorneys. What I would actually say is I think it actually is going to mean there's going to be more legal work, because with that dumb work set aside, for the software and the robots to do, that frees up bright attorneys to do more interesting, more complex work. And I would actually argue that we'll see more legal work in the future because they're not stuck doing all this dumb stuff.
You've got a rosier forecast than some. I was recently at a conference where beamed in as the keynote speaker was Richard Susskind, who is probably the legal technology futurist. Mm-hmm. His view was that generative AI is going to, and I hope I'm being fair in how I characterize this, that generative AI is going to displace almost everything we do as lawyers today. And that by 3 years from now, if we haven't figured out how to totally recreate ourselves, we will be totally obsolete. He suggested that what we need to do is figure out, instead of being lawyers, figure out how to better talk with ChatGPT or whatever it will be in 3 years, and figure out how to write prompts, and that is going to be our future. What do you think about his view?
I think first off, he's brilliant, and I do certainly follow his work, and so it's definitely something to take into consideration. I think people should be prepared for dramatic changes, and the world is no longer these big law powerhouses. What you're seeing with the new technology is a force of equalization where, boutique litigation firms like the one I work at are able to work with more advanced technology, and we're able to move faster as a result of that. And so I think the legal work is going to go to, there's going to be cost considerations where the lucrative work is going to be driven down. It's going to be cheaper. You're going to be able to do it faster. But there will be dramatic changes that come with that, along with robotic process automation and stuff happening. But I don't think, maybe I'll answer it another way. Attorneys are really good with language, and I think they will be the champions of this technology. And I would quote a technology optimist, Kevin Kelly, who is the the co-founder of Wired Magazine and someone whom I'm a huge fan of, he's mentioned that his take on generative AI and ChatGPT and all of this stuff is much more optimistic. And if folks catch his interview on the Ritual podcast that he did recently, he talked about this specifically. What he said in that, and I'm just paraphrasing, was that if it turns out, because these large language models and this generative AI is taking all of the text that we have on the web, if it turns out that humanity has just published a ton of like racist and terrible content on the web, and that's what the generative AI is pulling the text from to make these answers, and in lots of cases making up answers. What we can do, as the writers of this code, is we can make the code better, and that was his optimistic take, is that if we see it going in a negative direction, we can write the code better. It's just code, it can be changed. And so I like to take that more optimistic view, that there is a more positive future out there. But I do totally agree that the timeframes may be short. It may be 3 years, it may be less, where we have to adapt. And I think that I think will be challenging for a lot of folks. There are a lot of people still practicing law the way it was 20 years ago, and that's not the case now. We have lots of really cool, fancy technology, and the people that are going to win the big, lucrative legal work are going to be people that are fluent with the technology and able to apply it effectively to their practice of the law.
How do those who are practicing in the old ways and who are not fluent in the technology get to that place where the future won't be dystopian for them?
That's a great question. I'm not sure.
Well, if you have an answer, I've been trying to figure out the answer for 35 years.
I mean, I personally am like an early adopter, and I enjoy trying new things, and I enjoy being surprised, and I have like a rosy outlook. And I don't hesitate to try new things, so I think that makes me like more uncommon than folks that like find something they like and then just stick with it. But I think when you see this tidal wave of change coming, you have to level up and adapt, and there's honestly, there's probably lots of organizations that are going to help with this change, ACEDS, ILTA. When they see their peers making these dramatic changes, that's when they're probably going to change. It's probably the easiest way.
Yeah, I mean, a small example of what perhaps could be done. I was just at a retirement party for a former colleague of mine, and talking with the woman who was high up on the administrative side when I was at the firm, and it still is there. She was talking about a recent board meeting they had. She's been frustrated that they all have paper printouts. Yeah. She was asking, well, what do I do about that? And someone said, it's very easy. Take the print paper away. If there's no paper in the printers, they can't print the reports. She sent out a notice saying, there will be no paper. There will be no paper in the printers. You need to bring your laptops to the meeting. And I think maybe there's 6 board members, I forget. 5 of the 6 showed up with their laptops, which was a huge success already. Right. The 6th one got there, looked around, and said, wait a minute, left and returned with his laptop. So there are any number of ways, I guess, to nudge people in the right directions.
That's a good one. Yeah, if you have to. Take the resources away. Take the paper away.
Yeah.
I personally wish email would go away. There's just too much of it at this point.
Yeah, the problem. Email might go away, but chat's not going away.
No, and that's what interests me with data, and I've seen lots of cases where the text messaging, the short messaging, is actually not short. It is long form, but it's completely replaced or eclipsed people's usage of email. Yeah.
So you mentioned earlier, and now you mentioned again, dealing with chat messages, short or long, and how the attorneys at your firm now approach that and do it in a much better way. What do they do that is better and different?
I would say they go boldly into the data sources, and so with the Celebrate viewer, you can view the messages there, and now we have lots of fancy review options for reviewing short message data. Certainly Reveal-Brainspace, Relativity, Everlaw. There's lots of platforms out there that will enable you to chunk out the messages in efficient ways for the attorneys to review. I think the industry as a whole is still trying to figure out what the best and fastest way to do that is. So I'm not certain that there's like a formal best practice. And then with the changing nature of data, the other challenge is also the ephemeral aspect of it, disappearing messages. So several years ago, I started asking, anytime I have a call with a client, when we're going through what data sources are relevant to the case, several years ago, I started asking, do you use Signal? And the surprising thing is almost everyone is using it. And I just mentioned that, all the time, like that is a relevant data source, and we need better ways to collect and review, that data when it's relevant to a case. Because right now there's only 2 or 3 options for pulling that out, and it's not great.
There's another side to dealing with chat messages and the like that doesn't get discussed as much as I think it should in eDiscovery circles in particular, but which you might have a good take on given how many cases you all take to trial and how often you're in the hot seat. What are more effective as opposed to less effective ways to get that content in front of a judge and in front of a jury so that it makes sense to them and help, and you can then work with it in a useful fashion?
As far as like presenting the evidence in trial?
That's right.
Yeah, I'm not sure I would venture to opine specifically on that, but getting it into a reviewable state, there's lots of options, and then for presenting it, usually you want it as close to source as possible, and then you want to explain how it was, or ideally have it presented in such a fashion where it makes sense, where the message came from. But yeah, that's all. The other thing that I would mention specifically about hot seat work is I haven't done myself hot seat work in, I want to say 2 years.
Okay.
2 years. So the recent trials that we've had, we've just worked with some incredible professionals that do that full time, all the time, and they are just seasoned pros.
Yeah, that's the presentation of content, whether it's chat messages or email messages or databases or whatever it might be, at trial and at hearings and even at depositions, I think is the forgotten piece of the EDRM diagram. But it's such an important part. And
yeah, no, I totally agree. And chain of custody and tracking where the origin of the files is extremely important. And having a defensible forensic collection, as well as how the process moved from where that data originally was, and showing all of the steps. And so, one of the things that I mentioned is when you are, chunking out the data in various steps, you always need to be able to go back to the previous step and have that existing, because, as you get into the facts of the case and your knowledge about it changes, you always need to be able to go back to the source and have that available. And so that's always extremely important.
I think that's such an important point, and probably one that's only best learned by being in the hot seat.
Right.
Well, Phil, thank you so much for joining us today.
Sure.
It's been a pleasure to talk with you. Phil Weldon is Director of eDiscovery and Litigation Support Technology at Kaplan, Heckler and Fink. I am George Socha. This has been eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. Phil, thanks again so much.
Thank you.